Hi, welcome to episode 5 of Kosovo Dispatch. I'm your host, Visar Jambazi. In today's episode, we will be discussing the draft statute for the Association of Serb-Majority Municipalities in Kosovo. The draft statute has become a major point of contention in the Kosovo-Serbia dialogue, with the EU calling on Kosovo to submit a draft statute for the association to its constitutional court for review. In January 2023, the European Institute of Peace, in collaboration with the Friedrich Ebert Foundation, presented a draft statute for the association. 5 months later, a management team consisting of Kosovo Serbs presented their own draft, which was rejected by the Kosovo government. In October 2023, the European Union presented its own draft statute to the Kosovo government. Despite these numerous proposals, there have been no serious efforts by the Kosovo government to submit a draft statute for review to its constitutional court. However, on May 16 this year, in an effort to advance Kosovo's bid for Council of Europe membership, Kosovo's Foreign Minister Danica Grvala-Schwarz sent a letter to the President of the Parliamentary Assembly of the Council of Europe. In the letter, she pledged that the Kosovo government would submit a draft statute to the Constitutional Court by the end of May. The letter also mentioned that this draft is inspired by the proposal of the European Institute of Peace and Friedrich Ebert Foundation. This is the first time that the Kosovo government has publicly endorsed a specific draft statute for the association. Joining me today to discuss this is Senad Sabovic from the European Institute of Peace and the author of the proposal. Hi, Senad. Thank you for joining the Kosovo Dispatch.
Hi, sir. Good to be here. Thanks for the invite.
Before we begin discussing the draft statute, let me first ask you about the Constitutional Court's 2015 decision. What did the Constitutional Court judgment say about the Association of Serb-Majority Municipalities?
Yes, great. Again, thanks for having me. And it's a good first question. This is fundamental. This is pretty much where it all goes back to. The Constitutional Court had this landmark judgment on the association that happened in 2015 after President Yahiaga sent this 2015 association principles for a constitutionality review by the court. And that judgment is fundamental for this process. It's good that you asked because there's this pretty strong misconception, I would say, in Kosovo, especially that the Constitutional Court declared the association entirely unconstitutional. That is not the case. It's actually quite the opposite. The Constitutional Court declared the association to be an integral part of the Kosovo constitutional legal system, and it very much presumes very directly throughout its judgment, which can be easily verified, it's online, that the association, the statute will be drafted and the association will come into existence. So that's the overall, conclusion of the Constitutional Court. Then, regarding particularities, yes, there are 3 points, 3 segments of the association only 3 that the Constitutional Court declared kind of not constitutional, not functional in our legal system here, which is to do with the relations with the central authorities, and it cannot only represent the Serbian community there, the ability of the association to initiate legislation and the ability of the association to initiate constitutional court proceedings other than to defend its own fundamental rights and freedoms. So these are things that are declared wrong, and most of the statutes did that. Regarding the other points, in some cases, numerous points, the Constitutional Court actually found certain correlations between the principles of the association, which is kind of the skeleton of the statute, and the constitution and legal system of Kosovo, and then provided, outlined the theoretical concern that in case the draft of the association is developed in a certain way, it may invoke certain constitutionality issues. And on those points, very importantly, the court provided very clear guidance how not to do that. In fact, in many ways, this judgment is kind of a handbook. It's a guiding tool how to develop the draft statute so that in a constitutional way, so that the end product is constitutional.
Yeah, obviously there's a Constitutional Court decision which calls on the implementation of the 2013 Brussels Agreement, where Kosovo government has agreed to establish an association.
Exactly.
The same agreement has been ratified in the Kosovo Parliament. So taking into consideration what you said and all these factors, then why does the Kosovo government refer to the association as a potentially new Republic of Srpska in Kosovo?
Yes, well, that's another good question and interesting, and it's a major dimension of this whole story. I don't know exactly, but what I can presume is that the governing party, in its activity as an opposition leader for a while, formulated this position. Then, when Dosia, now the governing party, was in opposition and perhaps as such didn't really have proper access to the process and a proper, full understanding of what this is. On the other hand, the certain concerns are legitimate. The concern over constitutionality and the functionality of the Kosovo state and so forth. These are legitimate concerns, and perhaps they're kind of easy to brand under this notion. This looks like Republika Srpska. So I would assume that that's the origin of it, and then why still to this day? Perhaps this position was stated numerous times very publicly by the governing party as while in opposition. So in many ways, the government is now compelled to maintain that position because having stated it so many times before, and perhaps a factor is a bit of strategic positioning vis-a-vis the dialogue process. Maintaining this position in order to perhaps replace the concept of the association and dialogue with the concept of something else, similar or not, or to kind of again tacticize in order to get a lesser association out of the process. That said, I have to stress that the association, in actual reality, the association and Republika Srpska could not be different. This is a night and day difference in these two kind of entities. We know that Republika Srpska is a constitutive republic, constitutive entity forming the state of Bosnia and Herzegovina along with the other entity. We know that the Republic of Srpska is a republic. It's a fully executive, has its own constitution, government, police, with the full state powers to govern its own territory. In addition to, to put it simply, 50%. A 50% stake at the level of the state of Bosnia and Herzegovina. It controls 50% of the state level and has its own, very homogeneous 49% territory within Bosnia.
On top of that, has veto powers.
He has veto powers. It's technically a veto power, but it's a power to control the decisions of Bosnia and Herzegovina. So not its own decisions. Bosnia and Herzegovina across the board, from the appointment of ambassadors to bilateral agreements, let's say trade, to recognition of states, as we saw in the case of Kosovo, whereby Bosnia doesn't recognize Kosovo because of the veto of Republic of Srpska, which is happening at state level. So all this is really could not be different to the concept of the association, which is a intermunicipal body there to serve the municipalities and their citizens, there to serve these 10 scattered municipalities across Kosovo, there to be integral into the to the Kosovo legal and institutional system and so forth, and there to be constitutional. And then we know that the Kosovo Constitution doesn't allow a concept like Republika Srpska. It's not anticipated here. So, yeah.
Well, now I'd like to turn to the draft statute that you authored. What are the key features of the draft statute proposed by the European Institute of Peace? And how does it align with Kosovo's constitution?
Our parameters were, to propose a statute that is derived from the first agreement of principles and the 2015 principles, that is fully legal and constitutional in the pre-existing, not changed legal constitutional system of Kosovo. That's not a third layer of government, and that, noting the previous parameters, that it offers a meaningful and effective service to member municipalities and their citizens. So those were our guiding principles. And in terms of the mechanics, which is also an important part of the mechanics of writing, were, let's say, relatively simple. As we noted, the skeleton of the association is the 2015 principles agreed in Brussels. And as we also noted, the Constitutional Court reviewed those principles and provided a guidebook on how to develop a constitutional statute for the association. So that's exactly what we did. We took the principles, developed them into a statute-looking thing, and constantly cross-checking with the all the points of the Constitutional Court decision. We actually also commissioned a legal review of the final draft by a leading constitutional law expert in Kosovo, and she concluded, she agreed with us that this would be fully in line with the constitutional and legal system in Kosovo. Otherwise, the elements are known. Again, it's the basis is the principle, so it has the bodies that are anticipated there. It has these functions in the policy areas that are anticipated originally, such as full overview in the area of education, full overview in the area of health, local economy development, urban planning, and so forth. These competences are not executive. So to give an example, if we're talking about full overview in education, we're not talking about the ability of the association to actually certify a school into existence. That we think is an executive power. But we're talking about the ability for the association to provide additional things, additional services to that given school, from purchasing a computer lab, some sort of special equipment, to providing certain expertise, bringing experts to bear, and coordinating the municipalities on improving their education system as anticipated under the Kosovo legal framework. Otherwise, it would have an integral budget and autonomy of using it, but again, there are checks and balances embedded in the statute for that budget to be approved under appropriate scrutiny by the government of Kosovo. So the government of Kosovo checks through the audit office probably whether the budget is appropriate to what the association should be doing as defined by the statute and the Kosovo legal system. Once that is passed, then yes, the association has the full autonomy to use its budget. And then there's also a system for the central institutions of Kosovo to, as they do, let's say, vis-a-vis the municipalities, to continuously follow what the association does and react in case of some sort of unconstitutional action or action not mandated by the statute, with a safeguard for both sides, I gotta say, as is the case in the relationship between the municipalities and the government, with the safeguard of the Constitutional Court. So if any of the parties have a claim, the Constitutional Court is the arbitration, which protects both sides. It protects the central institutions of Kosovo in terms of the association doing something beyond what it should be doing, but it also protects the autonomy, as it does the autonomy of local government, of the association from arbitrary interventions by the central institutions.
Thanks. How did the Kosovo government react to your proposal? Have you been in contact with them?
Yeah, well, we definitely shared our draft with the government of Kosovo prior to making it public, and offered to talk, offered to discuss it, offered to explain our full expertise and so forth. We did not get any response. We did not get any feedback, which perhaps is understandable for the time. I would put that down as part of Kosovo government's kind of strategic positioning on the issue in the context of the dialogue. Yeah, that said, I think we've seen more recently, last week, that draft seems to have been positively acknowledged by the government. So that's there. And what I also want to say is that I appreciate, given the brevity of the issue and given the general position of this government vis-a-vis this issue, I think the public reaction at the time was quite fair.
Yeah. Well, but despite several draft proposals from the organization you work for, European Institute of Peace, together with the Peter Shepard Foundation, then we had another draft from the management team, and more recently the European Union. Why hasn't the Kosovo government submitted a draft statute to the Constitutional Court for review, entering the fourth year of mandate?
Probably due to this, what we said earlier, and the difficulty that this government has on this kind of general notion of accepting the association. That's the primary, I would say, the primary reason. Otherwise, I really would have opted otherwise. This was a clear-cut situation whereby, the point was, even if unpleasant, even if technically perhaps should not have been related to the Council of Europe, but in actual fact, what was needed was a referral to the Constitutional Court of a draft for which the international community, the Western international community, has given advanced guarantees of constitutionality. One, then has offered that the evaluator of that constitutionality is Kosovo's own constitutional court. And then again, advanced guarantees were given that Kosovo's own constitutional court's decision will be respected by everybody post factum. So all guarantees of constitutionality were given. Kosovo, the government of Kosovo also kind of committed to it in their response to Dora Bakoyanni's report. So all that said, that act, which is just the act of sending to the Constitutional Court, it didn't mean let's establish this decision.
Yeah,
let's review its constitutionality so that maybe then we take other steps according to the Constitutional Court decision.
What if Kosovo government continues to delay? What consequences might arise if the Kosovo government continues to delay establishing the association or even submitted a draft proposal to the Constitutional Court for review?
Well, difficult to anticipate everything, for sure. Difficult to be precise about this. But one thing to say is that from looking back, I don't know, however long you want, but especially the last couple of years, for me it's clear, and it should be clear to everybody, that Kosovo's primary commitment in this process, and the only, is the association. And there's pretty much no engagement that will be acknowledged positively if this basic notion is circumvented, is avoided, is trying to be bypassed. Yes, things can be said about the other parties, commitment to the process, but I think it's about looking at your own commitments and trusting your Western partners that on their end. Now, obviously, we saw what happens. We had a very visual representation of what lies out there for Kosovo without accepting this, which is the Council of Europe story from last week. I think that's your answer to anything you can imagine. The Council of Europe membership was not put on the agenda by some of Kosovo's closest friends. It wasn't Serbia's lobbying and sort of the Eastern Bloc mobilizing against the vote of the Western Bloc, as was the case in UNESCO a few years ago. It was the very countries that actively lobbied a few years ago for UNESCO membership and unsuccessfully fine, but then successfully for UEFA and FIFA membership and many other things, that were now the same ones that did not put this issue on the agenda. So what can you expect from, let's say, any attempt at EU candidates or NATO membership or NATO pair partnership for peace membership or anything you can think of, ahead of us? Anything out there that is in this category of consolidating Kosovo statehood internationally cannot be expected to be done and confirmed without this. Another thing that I'd like to add is these days we hear, which is kind of a dimension of this whole story, we hear that Spain has or is recognizing Palestine. I think it's an interesting case study because this kind of blows up the center of Spain's argument regarding Kosovo's recognition. Had Kosovo properly remained committed to implementing its share of dialogue commitments, the West would have stayed fully on its side and would have stayed fully committed to lobbying for Kosovo's recognition of statehood left and right in the world, and would have now approached Spain to insist on at least simultaneous recognition of Kosovo along with Palestine, and would have had the arguments for it.
Senad Sabovic, thank you so much for joining the podcast.
Thank you. It was a pleasure to be here.